Good afternoon to everybody in the room at the Gateway Club. Welcome to Safer Every Day. Welcome to those who are on Teams. I've already briefly alerted you to sort of some housekeeping rules to the team members. Welcome to today's event. We've got two presentations taking place. Sue Duff from the Quality and Patient Safety team, it was one of the Quality Improvement Managers, will be hosting both of those with support from colleagues both from Mental Health Services, the Institute and our colleagues at Guernsey Police. So we are sharing information around the processes around the Section 91s and Section 92 of the Guernsey Mental Health Law. That's our first presentation. And the second presentation is all around raising our awareness around perinatal mental health. Hopefully they'll be really interesting. Well, I know they will be because they are fascinating subjects. They're challenges for people who are delivering the services. For those on Teams, we've got Claire, who is the manager of the Duty and Brief Intervention team and an ASW. She couldn't make the event but would be standing up presenting. So Claire, for your information, if you've got any contribution to make, please make it in the chat and I will read it on your behalf throughout the session as it goes along. I will interject and interrupt your colleagues. But hopefully it will be a great informative session for both topics. In addition to that, just to also highlight, then the last event for this year for Safer Every Day is the QI Clinic on the 14th of December, again hosted here and on Teams, and that we're going to look around human factors and incivility. So hopefully quite an interesting topic, talking particularly around how incivility can put patient safety and at risk. So yeah, a really crucial part of how we deliver and ensure safe services. For that, I'm going to hand over to your first presentation, and that is the processes around the Section 1 and Section 92.
Thank you, Vicky. So for those that don't know me, my name's Sue Duff. I'm the Quality Improvement Manager for mental health teams and services, Alderney and the prison healthcare. Do you want to do your?
My name's Paul Grantham. I'm the Mental Health Law Administrator for the Bailiwick of Guernsey.
My name's Jess Lane. I'm a Police Sergeant at Guernsey Police. I'm sort of Deputy Mental Health Lead on Guernsey Police.
And finally,
hi everybody, Liam Johnson. I'm Acting Chief Inspector for Operations and I am the Mental Health Lead for Guernsey Police.
and on Teams, as Vicky said, we've got Claire Lindsell, who's an ASW and the manager of the duty team. The other person that we should mention is John Lyons, who participated in this process, who no longer works for the HSC. So I'm starting. I'll just put these up, get them all up for you. So this is what we're aiming to cover off today in the session. We're looking at increasing knowledge around Section 1, the 92, and also the writing of reports for the police. The Section 91, and I'll talk about that first, came about from a couple of incidents that took place where there was a lot of miscommunication between ourselves in mental health services and the police, and not knowing what the process was and whose role was what. So that's what led to this presentation and the whole process.
So, first question for the people in the room. What do you understand about Section 91? Nope.
Basic safety.
Sorry?
Is it basic safety?
Not quite, no. Section 91 is the power for us to apply for a warrant to gain entry into a person's home if we feel that they're at risk, their mental health is deteriorating, and we need to get them support as quickly as possible. It can be used, well, it says it can be used by and whom. This is one of the reasons we looked into this. This is something that the approved social workers can apply for to the Royal Court. So it's not a quick process. It's not something we can quickly write up, but it's something we can get, and we need to show evidence that we have tried other ways to gain access to this patient, this person, to make sure that they are getting the support they need.
So I was as naive as everybody else when we started this process. And we sat around the table with mental health, with ASWs, with the police, with Paul, and with a gentleman by the name of Simon Hodgett, who is the law advocate, basically. And we looked at how could we break this down into easy bite-sized chunks so that people could understand it and follow it relatively easily. So the next 3 slides cover off the Section 91, and we have been through this with a fine-tooth comb. It's been out for consultation with all the ASWs in the mental health service. It's been out for consultation with the police and, as I say, with the law officers. And so we've come to this process flow. Can you see that okay, or do you want me to talk through that? Okay, so if you've got a concern of an individual around their mental health, a visit takes place, which is the second one, and access is attained. If access isn't attained, then we have to return to the office to review events with the team and the RMO. If access is attained, then it's straightforward and we go down the review and Mental Health Act is required. Once we've made the decision, as Paul said, to apply for a Section 91, staff need to be asking themselves, can that application wait until the next day? We don't want to be putting in for an application at 4 in the afternoon, which puts everybody under pressure to try and get that through the court system if it can wait till the morning. Okay? So if it's yes, we review the access next day, and if we need to get there, we'll go in. If it's no, then the application is applied at the law officers of the situation and the intent to apply for a 91. What we've put at the side is where a Section 91 is considered, all mental health staff must review any service user of concern with the duty manager within office hours, and a Sainsbury risk assessment must be completed for all service users of concern. So we've then got the next part, which basically is the planning stage. That's how I describe this. And it's liaison and setting the scene with the police, because what we found from the reviews was that this was the part that we had the greatest confusion. Who was doing what, how were they doing it, when were they doing it, and who was letting the police know? So we contact the duty inspector by telephone, appraise them of the situation and intent to apply for a Section 91, and review their availability, because they might not have sufficient resources available to assist mental health with this process. And then identify who the lead mental health person will be, and generally that's whoever the ASW or the duty team person is going into the home. Feel free, boys, to contradict me if I get this wrong. The duty inspector provides the ambulance with heads up. We also involved Amy from the St John's ambulance on this, so we were all on the same page. On the other side, we've got, following the initial agreement to act, a multi-agency briefing to be undertaken at the police station and led by the duty inspector, with attendance from mental health ASW and relevant RC, to ensure roles and full details of the situation are known. And that's so everybody knows what each other's going to be doing and how they're going to be doing it, and there's no surprises when they actually turn up. Notify the acute ward of the potential admission. Print 2 copies of the Section 91 off for the bailiff to sign, 1 for the file and 1 for the nearest relative. Present at court, and then when the Section 91 approved? Yes. Notify, update the duty inspector as soon as practicable. If no, review and act as required. If police are unavailable due to higher priorities, what is the contingency plan? So we have asked the staff to think about what measures they would put in place if the police aren't going to be available, because there could be a major incident going on that they can't come away from. Then the ASW attends the police station, a pre-home visit briefing with the police and ambulance crew, which should include background information about the service user. Are they likely to be violent? Because police and ourselves obviously want to know that information. Do they have access to weapons? And again, we need to be sure that people are going to be safe. and the approach that we're going to take. Agree that who will lead, who's going to look at the premises, and notify the ambulance of approximate time of arrival. What we found from the after action review when we went through that was that in the event that I'm talking about originally, the police turned up, mental health turned up, mental health left, the police left, and the house was left open, unattended with the front door open. And so somebody had to go back and secure it. Okay? And I think that's been working well so far.
Just to add a little bit of meat to the bones, Sue.
Yeah.
So this is all about a two-way conversation and about us communicating well together. This isn't about how we dictate to health services or about how health services dictate to us about what's happening, because it's clearly been a failure in communication often, and where one particular organisation presumes that the other organisation is doing something or taking responsibility, that presumption makes a fool of both organisations, because then we miss things. So that is the key to this. For a little bit of background around policing, and we are making a presumption, and we make a presumption that you understand what the policing organisation looks like, but PCs and sergeants generally work on the response shift, and the inspectors have ownership, okay, and incident management ownership for each of the individual shifts. There will generally always be an inspector on duty, and that inspector, particularly over weekends, is the senior officer who will be responsible for all policing over weekends and in the evening. These things tend to happen over the weekends, and in the evenings that's just the way they work. So yeah, it is all about good communication. It is all about us being able to come up with a plan between us. In an ideal world, a 91 shouldn't be rushed. A 91 in an ideal world should be planned and should give us the best opportunity to work together for the best outcome of the patient. That's the idea of the workflow that Sue has designed.
One of the things that came out from the after action review there was that one of the police officers actually knew the family, and so the 91, when it was rushed through, didn't need to actually take place, because the police officer could have got the person to come out of their property. So having those communications and having that good relationship is of benefit to the service user.
Sue, can I just
Yeah,
ask?
yeah.
I'm the ordinary social worker, and obviously I'm a social worker. I'm not resident in Alderney, nor is there an approved social worker resident in Alderney, and I just want to know what happens or what does happen in the Alderney situation.
Okay.
Someone could.
Do you want-
So the James Taylor is the sergeant in Alderney. There is currently some work going on between HSE Mental Health Services and the police in Alderney to fully understand what the process is and what the full process is there. At the minute, we've just invoked the MOU on voluntary attendance, which is now going to be rolled out across the bailiwick, so including Alderney as well. But with regards to the 91 process, the process should follow the same workflow. It should follow that availability. You know, if we get that information, we have some concerns about someone, and then following it through. The key again is how much time do we have, and how do we plan that? If that communication, that early communication is put in place, then yourself as the Alderney social worker will hopefully get that early heads up that there is a concern, but it will likely come from somebody within health services, hopefully, or through the police who go, oh, we've got concerns, and somebody's at home. But we still need to follow the workflow to make it legitimate and make it lawful.
But I'm not a mental health social worker. That's it. I'm not an approved social worker.
Yeah.
That's why I wanted to say. And you've said obviously it's an approved social worker. Is an approved social worker then called to come over from Guernsey to Alderney?
So what we've done is JT has been involved in this as well, Margaret, all the way through. And what we've done is we've set up processes where they can actually access via Teams and talk to the ASW. It will be slightly different in that they will then have to go through the process through the Jurat in Alderney. But to date, I don't think there's been many in the way of Section 91s implemented in Alderney, predominantly because people know each other and predominantly they can get the person to come into the hospital. We've got a hand up.
I just want to contribute from Claire, if that's okay, as obviously she would be here in person. Claire has just said currently the expectation is that same process would occur in Alderney, with the only variation being is that the warrant is granted by the jurat from the Court of Alderney, and yes, the ASW would be expected to attend for a warrant execution. Can I just also, any questions that we have, can we do at the end of the session, just to allow us to keep things on track, both on Teams and other than Claire, that's the only reason why I'm reading out Claire's. So back to you, thank you very much.
So then this is the final section, and this is really the implementation. And basically the ASW, the RMO, police and ambulance coordinate an arrival time. Section 91 is enacted. The police to facilitate lawful detention and consider the threat, assessment and suitable transport to the place of safety. The police then leave. It then falls all onto the ASW and Mental Health Services. So the ASW then takes the lead role. They review the service user, complete the assessment if possible in the home. They detain them under the Mental Health Law, and or if they're willing to attend for an informal admission, which is preferred, then that's the way they'll go. If that's a yes, the ambulance transports the service user to ED or Oberlins. If it's no, offer the mental health service. If declined, no further action. So that's if they're assessed and they don't need to actually come into the service. The agreed person secures the property and provides the nearest relative with a copy of a Section 91, which I don't think took place, did it, at that review that we did. And then there's a post-action debrief to review what went well, what could have been done better, so that we can enhance and review it going forward. The acute ward is advised of the time, the approximate time of arrival, and they have asked that access is gained through the back door rather than bringing somebody through the centre of Oberlins wherever possible. Under law, a mental health practitioner must be present, and this can be the ambulance crew. And Herman Alderney follow the same processes. SARC uses medical professional and the Sensual steps into the ASW role. Okay, and I'm going to hand back over to Paul and to Jez.
So, similar question here first. For a Section 92, does anyone know what this is? Yes. The important part about Section 92 is the person needs to be in a public place. So as long as it is a public place, a Section 92 can be used by the police. And when we talk about place of safety, we are generally speaking about the emergency department here, the police custody state if the person is violent, and we'd only use police custody if there was violence. Or if we have a plan in place, they could come to the Oberlins and we have a team ready to meet them and assess them. Primarily, they go to ED. And as we said there, who can be used by and when? The police. This is a police order.
Okay, Section 92's, as was referred to, this happens in public, so the person who's being assessed by the police or detained by the police has to be in public. Can't be in a private address, so it has to be in public or with access to. That's mainly why we get involved. When we deal with them, we'll assess them as high risk, medium risk or low risk. If they're high risk, as in they're violent, they're threatening violence, as a place of safety, they will generally go to the custody area because it's not safe to take them to the ED department, given the staff and the other patients, you haven't got the facilities for them. If they're sort of medium or low risk, we'll then generally bring them to ED, where they come for an assessment. Now, if they come here as a low risk, or come to ED as a low risk, we're looking at being assessed by the on-duty doctor or the mental health team if they come out. Now, quite often, the people who experience these mental health episodes are either intoxicated or under the influence of drugs. So, unfortunately, it's very hard for mental health services to do an assessment on somebody who's under the influence of alcohol. that then leaves us with the issue where we have patients being detained at the ED department for a number of hours until they're sober to be assessed by the mental health team. So that's something that we're looking at how we develop and how we work on and what works best for all the different agencies involved. But basically, if they're low risk, they'll stay here, stay at the ED department, looked after by us. When they're sober, they're assessed by the mental health team or the doctor, and there are formal handovers done, and they'll sign for the patient to be looked after. And that's the limit of police involvement. Obviously, if they're taken to the custody area, again, they're detained under mental health legislation, and they will stay with us. Alternatively, we'll stay here with them until they're seen by the doctor the following day. That sure makes sense on that. So the service patient identified as requiring mental health assessment, yes. So they obviously stay with us, stay in the A&E department, examined by the doctor, rule out any physical causation for their mental health episode, and they're detained for the mental health assessment. Once that's done, they'll either transferred up to Crevishall or they're deemed to be fit to be released, and they go out and kept as an outpatient or whatever, kept from Longpool. As far as I'm aware, the Minnow Hospital up in Alderney is exactly the same system will apply for the Minnow Hospital for Alderney patients.
The only difference being the Jurat again would come into operation,
Yeah.
and the SW would apply for mental health law through the Jurat if they were deemed to need to be coming in under mental health law. For transportation over to Guernsey to be seen, they would still be transferred into ED in Guernsey, and they would come over by plane or the Flying Christina. It would very much depend on a case-by-case basis, and the police and the duty team via Teams Link would make that call whether they were safe to come on a plane or whether the Flying Christina was required. Police officer, if they're under section 92, which would be one of the team over in Alderney, would come over with the patient.
Basically, the police will stay with the patient until they're effectively signed for by the A&E doctor in charge or the mental health services. They take control of them. So we'll stay with them. If they're under our control and they're assessed as needing to be admitted to the Crevishall, then we will look at staying with them until that's done. The transportation of the patient from the A&E department, place of safety, to the Crevishall is not a police responsibility. That is down to the mental health or the HSC to organise. So they'll call an ambulance, transfer them by ambulance. Because at the end of the day, they're a patient. We don't want to criminalise them. We don't want to put them in the back of a van and start shipping them up to the Crevishall, Oberlins, whatever you want to call it. We want to try and treat them as patients, so it's not our responsibility. We'll stay with you for potential risk or threat factors to look after the staff and look after the patient, but the actual transportation is dependent upon health and social services for that. So, as I said, doctor completes cessation from section 92, so he's been seen by the doctor. Sorry, next one. That middle green one there, doctor completes cessation of section 92. That means section 92 is over. It's been assessed. We generally leave. That's when the mental health services will kick in with any follow-up as outpatients with regard to mental health services, or they admit them as an inpatient. Obviously, the mental health will be done by the approved social worker, and the duty psychiatrist will come out to do the mental health assessment within the place of safety, albeit A&E or with us if it's in the custody area, be released. And that's pretty much how the 92 works. Have I missed anything off, Liam? Sue?
I think just for a lot of currently around this work, this is very resource intensive for policing. It's also resource intensive for health as well. We are bringing people to ED because from a layman's viewpoint, our officers have concerns for the welfare and mental well-being of a patient in the public. We are absolutely trying to come away from criminalising mental health issues, and we must sort of try our best to ensure that patients get the best treatment that they can, and that's about us working closely with health services. We will do everything we can to not take people in police vehicles, to not take people, patients ultimately back to the police station, and to not in any way, shape or form criminalise people, because every time somebody sees that van, that marked vehicle, that police uniform with another person, they make assumptions, and it's unreasonable and unfair. This is best practice in the UK, and it's what we're trying to also invoke here. But it's really important that for us to do that, that we also work closely with health services here. When we get to ED, you know, where's the appropriate place for us to be? Where can we be put where we're not having that impact of us just being with someone? How quickly can we get patients seen? And ultimately, yes, alcohol, drink, drugs, they do affect how quickly we can have patients reviewed. But on the other side of that, the doctor in ED also has the power to sign off that patient if they are content and happy that they don't see any risk from them, or significant risk at least, and that there's no need for the police to stay with them. And it's about educating everybody that you don't have to wait for the ASW and the duty psych team to come in maybe many hours into this situation, and you know, there can be some sort of risk accepted. In the meantime, if there is a risk of violence or otherwise, then the police are going to be there to support our health colleagues throughout this. So it's about achieving that balance. And in the end of the day, it's you guys within health who have all that extra training and all that specialist knowledge who decide what happens with these patients, and the police don't have that knowledge or experience, and we're looking to you to help us to safeguard these people.
And I think one of the learning points for me was that if the person isn't deemed to need to come into Crevachon under the mental health law or voluntary, and they're going to go home, but they're going home with the plan, is that the ASW has to sign off on that plan. And I wasn't aware of that until I started doing this work with the ASWs, with Paul, Liam and Jez. Do you want to say about your piece?
Yes, the other bit we've brought up before is that paperwork that gets completed for Section 92s, we need to get copies of that up to me so we can keep records. We can identify if a patient is a recurring patient, so we can have plans in place to support both the police, ED, the patient, to make sure we reduce these occurrences of Section 92. So the paperwork is very important.
And I think the other part is that we work in collaboration with ED as well, so that they are very much aware of if there is somebody at risk out in the community that we think might present, and they let ED know. And I think they're starting to they're liaising with the police as well to let them know. So we're all working collaboratively for that individual. Yeah. I'll do the... Thanks, Jazz. Oops. Has that gone too fast? No. I'll go back. So to do this process, we started using the PDSA cycle, but I'm not going to go through each part of that, but basically Plan, Do, Act, Study, Act. And we've gone through every segment of this, not just once, umpteen cycles. I would say probably about the 5th, 6th rewrite of these two processes, because each time we'd find there was a better way of putting that process flow through. And it's hoped that we're looking at an ED document and looking at including in the document the MOU between mental health services, the police and ED, and then also these process flows will go in there as well. In the meantime, I'm probably going to put them on the quality part of the intranet so that people can access them if they want to see them really easily. But you'll all get copies of the presentation or be able to access it if you want to see it in more detail. And so, final part from me. Oops, I've gone the wrong way. It's basically just what I've said around how we've been doing that process flow. It's a continuous cycle, and even though we're at this stage now, if down the line we find there's something that we can do better, there's a way of improving that process flow or making change, then we'll get back together and do that. Yeah, and I'll hand over to Liam and Jez for the next part. There you go.
Okay, just let's have a quick input on police statements and reports. These are the statements side of it will fall into two categories. You have the statements, medical statements, where you've treated a patient, so we need your medical qualifications and the nature of the treatment you've given. On the other side, we've got, say, for instance, let's use mental health example. You've had a mental health admission at A&E, you've been dealing with him, and a member of staff's been assaulted. And then we attend, we do what we need to do when you arrest that person. Those sort of statements we need fairly quickly. And I understand you have your own protocols for prior to completion of a statement, they're checked by member of staff to make sure there's no admissions and those sort of things. From our side, as a police officers, statements are quite important for us to be able to take actions against the individuals who may have caused a disturbance, may have assaulted somebody, may have damaged or stolen something, whatever. Quite often we need those statements quite quickly. So we're looking at how best to get that done in both protecting yourselves when you're making statements, and also us to be able to obtain those statements for us to carry out the processes we need to be able to interview, potentially review the evidence, and if necessary charge them with any offences. So that's why we ask for statements. Obviously, that's our evidence. That's what's enabled us to take action against somebody. Police reports are slightly different. We often ask for medical reports, but there's a set procedure within the police that goes through a set organisation here that asks for medical reports for treatment that's been given. So I'll go through the format of those, and we'll go through the statement forms in a minute as well. Now I think they go to Vicky, don't they, statements? Yeah, they go to Vicky, she'll have a check of them and they come through to us or the OIC. What will happen is you'll have an officer will actually come up, so I'll just go through these. So that's the police statement form, basically basic details that go on here. If I could explain what happens with your personal details on a statement form, they are not disclosable to anybody. So when you give a statement, you'll be asked for your date of birth, your personal details. Those are not, they are not given to anybody else. We need those details recorded. However, they're not disclosed to any offender or their advocate or anything like that. They are what we class as non-disclosables. They're not disclosed to anybody. Your statement will be with your name on it, but no other details will be. So your details are protected. They're not disclosable. So an officer will come up, will ask you to complete all the relevant details, names, dates of birth, etc. When they're doing the statement, what will happen is the officer will actually ask you to provide details of what happened, so they get an account from you if you like. They might make some notes, and then they'll go through the statement with you in slow time, recording the information off you, getting descriptions. So for statements, we need as obviously as much details from yourselves, what can give us about description of individuals, actions, anything you can give to build a picture of exactly what's occurred, who's been involved, those sort of things. So that's it for statements, really. The officers who attend will go through what's required from you before they start taking a statement. Don't be afraid of making statements, because we need to be able to support you, and to do that we need the evidence, the information that you can give us to be able to take action against people. So it's very important that if you have seen something or you're aware of something, hold your hands up and say, look, this is what I saw, give a statement. It gives us a stronger case to get against people who may have assaulted you, may have stolen stuff from the department, wherever it is, or whatever's happened. I know I keep referring to A&E, but the cost of all the sort of health and social services.
The issue of a statement and report came out during an ED governance meeting with regards to how we can support staff members who potentially have been victims of crime, and looking at internal policies for HSC. What we can't do to any person at any time is force anybody to make a written statement. So please understand that. We can help you through the process, and we will always do our best to support everybody, no matter where they are or from what organisation or anybody in our community, to provide evidence where they have been a victim of a crime or alternatively have witnessed an incident that went on. But it is absolutely reasonable and rational for the police to take statements, and it's a requirement of us to present official documentation to the court and to prove beyond all reasonable doubt that an offender has committed an offence. That is the basis for why we take statements. Reports, as Jez alluded to, are slightly different in the fact of that is for us to be able to build information about the case, and we all know, I'm sure in this room, about that legal privilege and medical privilege, and we tread a fine line. We don't want to cross that line into information that we shouldn't have or don't need to have. So it's really important that we work closely with the organisation HSC as a whole, and that's why we put in safeguards to make sure that managers of staff members are included and informed that we're doing an investigation. If at any point anybody has ever been victim of a crime and feels they want to report it, we will always take that information. There is not always a guarantee that at the end of that information taking that there will be an outcome of a court, because people do things for all kinds of different reasons, and especially in the context of the mental health arena, do they have capacity or don't they? But the reality is that's supported by some other work that goes on. But you may be requested within your professional role to provide a statement about what that is or what that looks like or what happened to you on the day. We will never force you to do that, but there may be a requirement even from an organisational point of view that says that you need to provide us with that formal information. Please, Vicky.
So I'll just sort of step in how those processes work, particularly around requests from the police to assist with investigations. Be it from a medical perspective, you're being asked to do it as a health professional. So what we are offering, and I became aware of this in the 10 years of doing this role, that previously a lot of staff were doing this because it is part of your role and responsibility, but doing it with no support necessarily from HSC as a whole, and potentially could end up in the courtroom actually having to give that evidence in a court with no support, which may leave both yourselves vulnerable as the professional, but also the organisation, depending on how well we've constructed that statement, how accurate we've constructed those statement. Now, I am no expert. Okay, 10 years of doing the job, finding my way around it. I've gained knowledge and skills around that, and can therefore offer to staff to review your statements to make sure we've considered everything as best as possible, to clarify anything with you that I think may be misunderstood or not clear to other people who are reading those statements. So that's where we come into as part of the key process. So where we don't want to slow things down is, as Jez has rightly pointed out, if they're trying to put some charges in place and they can't detain anybody without having some evidence, they need that statement there and then. I'm not trying to stop that process, but where there's any possibility, even as a result of that, where you might have to go to court and present and stand up and witness to that, please share your reports with me, your statements with me, so that I can support you through that, attend with you wherever possible. I may not be able to, but wherever possible, we will also be in attendance, because a lot of staff have expressed real anxiety about being in the courtroom, about being pulled as a witness, because they are fearful, we live on a very small island, that there may be consequences as a result. Now, whilst I can't guarantee that, there won't be. It's trying to demonstrate to you that HSC cares about your well-being, even in those scenarios. So medical reports all should be coming directly to me, who then sends it out to the areas. The police do know that, and that's a formalised process that we've got in place. And most of the time it happens, but sometimes it may not. So if you happen to be asked and you think, oh, Vicky, it didn't come from Vicky, maybe send it to me so that we can make sure we do know about it and that they are asking reasonably and fairly for these statements. We cooperate at all times. I've never not. No, everybody has cooperated. We always provide those statements to the police because we believe we should, to support the police in their processes. But we'll check it over with you. I will also consult the law officers to also get their perspective on it without compromising the case. So there is a mechanism of support from the legal side as well. So that is there. It's not just an offer, it is a requirement. There is a policy in place that we are up for review, which is dealing with official agencies, so outside of HSC. I'm going to try and use that policy, which has been given to me to review, as an opportunity to feed this process in, so it's reliably in policy and people can sort of know about it. It's more at the moment, sadly, word of mouth and those who've been exposed to that process. But now you're here, hopefully that will also help you, those in the room who've never done it. But there's plenty of people around who are aware of that process being in place. So, sorry, over to you.
Would it be beneficial to have the police documents in that policy, just so people can see them and not be...
The police documents are the ones I provide you, so I provide that. And I go through exactly what Jez and Liam have sort of highlighted there, what is shared, what isn't, how it looks, I review it. I also witness it for you, so I sign it, I get you to sign it in my presence. I then witness it, I send it down to them, I send an electronic version down to them as well to speed things up. So we try to do all of that in a relatively timely fashion to try and help you all. Most of the time, they've never ended up going to court, the ones I've provided, thankfully, but there have been a couple.
Moving on.
Yep.
So hopefully we've met the aim, that we've increased knowledge around the section 91 and 92 processes and about the police reporting. And I would like to say that Paul does an excellent training on the mental health law. So if you want to know more, have a look on My Learning and join up onto one of his sessions. And the only other thing I'd like to say is a big thank you to Liam and Jez, Paul, John and Claire, because without them we wouldn't be able to make this really nice and clear for everybody. So thank you for your collaboration in this. It's been really appreciated. Any questions?
Over to you for questions and those on Teams if you have any. I'd like to just sort of say one thing from a Safer Everyday perspective, which is around quality improvement, is that, okay, yes, we've had Sue's help because Sue's in our team and understands quality improvement methodology, but Sue used a really simple tool of the PDSA to work through and tweak and make improvements on a process that we were trying to make clearer so people understood it. That PDSA cycle is really easy. It happens really quickly. It's not something that has to take hours to use. It's not something that has to take weeks before you can make those changes. It's something that's really useful. So this is part of the Safer Everyday process, is around bringing to your awareness how you can use things like that in your own areas to make changes, to review things, to review processes. So it's a bit of the Safer Everyday bit there that I'm just sort of flagging up, is around those quality improvement measures. What I'm planning to do next year for Safer Everyday, and I'm hoping people will think it's of benefit, is to perhaps spend a bit more time going through the medical reports process, what those statements might look like in reality. Let's give some dummy run-throughs of how to do those, and we will be looking to cover things like the lasting power of attorney, and we will be looking at inquest processes and what that looks like as well. So those are topics of interest that I think hopefully everybody in the room, but hopefully others across organisations will be interested in participating in, and that's my priority for next year, to look at those kind of things.
Just a very minor question, really. Is it a legal requirement to give a copy of Section 21 to the next of kin, because they might not always be the most appropriate person? Could it be somebody else?
The Section 91, yeah. It depends. It's down to individual circumstances, really. If they're not the most appropriate person, if they're involved in something, then we would consider giving it to someone else. But it's hard to say. It is different in every circumstance. So
okay.
yes.
But it's not. You have to give it to them full stop.
Yeah.
Thank you. I do have a couple of comments on here that I'm
Just share. So, Pauline Caddock, as an employee of Adult Disability Services, what is the procedure when staff are assaulted by service users with a learning disability or autism or mental health impairment?
So this comes back to the statement writing and the policies. I believe HSC have developed a slightly new policy going forward. I think it may even still be in the process.
It's in the process.
In the process.
So it is being worked on. So there was a lot of signs went out around the building about a zero tolerance policy, and that created a little bit of confusion, I believe, for some staff. Insofar as we still have a legal obligation to prove our case beyond all reasonable doubt. If staff members are assaulted, no matter by whom or in what circumstance, they have every right to report that to the police and feel that they will be supported. And that is our approach. And it is also the approach of HSC. That does not mean that at the end of that process or that report, that there is always a guarantee that this process will go through a court process and end up with an outcome, because we have to prove, that that person had mental capacity at that time. And because we're talking about a legal obligation here, we're talking about, could that person, in our police jargon, build a mens rea, a guilty mind over their action? Were they truly in control of what was going on at that time? And could they reasonably have foreseen that what was going to occur would have been an assault in the mind of everybody else? I'm trying to keep that as simple as I can. And I'm sure that there will be law officers who would absolutely talk to you at greater length over these areas. The reality is we can report it and we can record it and we can support individuals through that process, but we also need to manage expectation so that everybody understands that this isn't just us saying, no, we're not responsible for it, but what can we do moving forward to safeguard? That's about how we work with HSC as well. But there may not be a criminal conviction at the end. We just have to say that.
In my experience, and on to what you're saying, it generally goes to a swarm, and there's usually new processes put in place to manage it.
Yeah. So internally, people would obviously report that as an incident. We in the Quality and Patient Safety team would review that, look at the processes, look at where we've got opportunities for learning. That still does not, as Liam is rightly pointing out, stop anybody actually taking a formal step towards potentially making a complaint and wanting to log that with the police. I know from experience, being a learning disability nurse, that there's a lot of us who are very reluctant to do that within adult disability because of the capacity issues and because historically maybe we've not had the right support from the police in the past, and things are, that's massive. Things have changed massively in relation to that, and we are concentrating heavily. We worked heavily on our management of violence and aggression policy internally, because whilst I was tasked with having to write the last one, I was tasked with having to do the right at the time without being able to really look at things I really wanted to, which were, how does HST take responsibility legally with the legal support to actually support you as staff? Because I'm very mindful that we're doing a job and we're on the job when those things happen. And part of me still feels, and I'll be honest, I don't know where we've finally got to with this policy yet, because we're still working on it. Part of me feels that it's almost should be HSC taking that person to court, not an individual. And that's how I feel. So that's my personal feeling. I'm not quite sure where we've got to in the policy, so I don't want to confuse things there. But very much want to have that kind of ownership somewhere, that HSC is there backing you, a bit like I've talked about in the medical report. Somebody does care about you going to court to provide evidence. You're doing it for your job. We want to help you with that and support you through that process. So, so that's I could go on for hours, but I better not.
The policy's been rewritten completely. The law officers have been involved, and the law officers have said that we've got to, from a HSC perspective, that we have to support employees when they're putting things in place. And the policy is currently with Don Lewis from Health and Safety, because as Vicky said, it sits under HSC, but it actually sits under Health and Safety. So there's been a complete rewrite with the involvement of the police, with the involvement of the law officers, and with the disaster management planner as well. So that
Can people like Pauline access that to see that information?
if you email Don Lewis for a copy of the draft so that you can have a look at it, because it should have gone out for consultation, and my understanding is there's still a few tweaks taking place.
Until it goes out for consultation, I think it's probably better to sit. It will follow a process. All policies go out for consultation, so it's not there yet. So I think it's probably better to wait for that, but it should be soon, Pauline. Can I just comment on Claire's? I'm very mindful we've got poor Lucy sitting in the wings waiting to do hers, and it's been really good, and I don't want to miss that either. In response to your question, sorry, lady on the front row, don't know your name. Claire Linsell said, I think the mental health law nearest relative is much more applicable than the next of kin. So that was around whether the next of kin in the section 91. So, and sorry, there's another bit from Claire. And it is not a legal requirement that they are informed of section 91, but it is good practice. Decisions would be made on an individual basis. If, however, the outcome of the section 91 is to make an application, i.e. to detain someone, there is a legal responsibility to inform the nearest relative, and we would only disregard this in a very exceptional circumstances. Thank you, Claire.
I'm just looking at Lucy because we're due to do the next one. I'm wondering, to do the next presentation justice, do we do it today, or do we, if people want to stay for it?
Well,
Yeah, exactly.
Probably going to have to go.
Yeah.
I'm
Yeah.
mindful of that.
Yeah.
I'm mindful of that. I don't know whether we can. I don't know what Ollie's diary's like, so I might have to have a conversation with Ollie whether we can get another session in. And I'm really sorry because Lucy's presentation is really good, and she does need to be given the time for that.
It probably does need the hour of going on how we've been today, because we thought we'd do this in half an hour. But questions and everything else. I think to do both topics justice.
Okay.
Yeah.
But can I just say thank you to Lucy, because she has been sat here the whole time, which as a mental health nurse and a practitioner, I'm sure she's found it very helpful and informative anyway. And please, those who've turned up for this, please do come back for Lucy's session. It will be very worth your while. And I'll try and get a date in. I might even look at whether I change that QI clinic, depending on whether Ollie has any availability on the 14th of December. But we'll see. We'll see what we can do, and whether Lucy has availability on the 14th of December, in fact. Yeah, I'm sorry, but I guess that's the way it goes sometimes. But thank you for those who've contributed so far today. It's been a really informative session. Lots of work gone in to a process that we've been all vaguely familiar with, but probably plundered around in the dark on occasions. So thank you for all the work you've done. There is a couple of people writing something in the chat, so just bear with us on that. But if there's no other questions, you're pretty much free to go, bar the ones that are on the chat. Oh. Yes, so there's questions around the slides and the presentations, and is it possible to have copies of the process flows? So we'll have to put those, I think we need to get those probably on Polyplus and the likes. So yes, Pauline, we can, not a problem. And there's lots of thank yous.
I'll send copies.
Yeah. So, yeah, thank you.